Today we're breaking down the case of Kilmar Abrego Garcia, his immigration status, the evidence Attorney General Pam Bondi and DHS cited against him, what was left out of public statements, and what might happen next.
Let's start with Kilmar Abrego Garcia's background. He first came to the United States in 2011 when he was about 16 years old, fleeing El Salvador. His family was targeted by the violent Barrio 18 gang, which extorted his mother's pupusa business, a business that specializes in preparing and selling pupusas, a traditional El Salvadoran dish, threatened to harm his siblings, and tried to recruit his older brother. To protect himself and his family, Garcia crossed the border illegally and settled in Maryland, where he worked in construction and eventually married a U.S. citizen.
What led to Mr. Garcia's initial contact with police?
On March 28, 2019, Garcia was at a Home Depot parking lot in Hyattsville, Maryland, looking for day labor construction work with 3 other men. Police approached the group suspecting them of loitering. As officers arrived, 2 men discarded unknown items under a vehicle, and police later found 2 bottles containing marijuana. All 4 men, including Garcia, were taken away for questioning. There is no evidence that Garcia was involved in any criminal activity. He was simply seeking work as a day laborer, as he had done before.
What evidence was used to claim Garcia was a gang member?
Authorities pointed to a gang field interview sheet from Prince George's County Police, which referenced his clothing: a Chicago Bulls hat and a hoodie with images of money obscuring the eyes, ears, and mouth of presidents on U.S. currency. Police interpreted this as a sign of Hispanic gang culture. They also cited statements from a confidential informant who claimed Garcia was an MS-13 member with the nickname Chile and a supposed rank in the gang. The informant also alleged Garcia was linked to an MS-13 clique in New York, even though he had never lived there. No criminal charges or convictions were ever brought against Garcia, and he had no criminal record in the U.S. or El Salvador. His attorneys emphasized that the evidence was thin and the informant's reliability was questionable, especially since the officer who authored the report was later fired for unrelated misconduct.
Was this evidence presented to a judge before Garcia was granted protection from deportation?
Yes. In 2019, an immigration judge held hearings, reviewed the police report, the confidential informant's statements, and the I-213 immigration form. The judge considered the clothing evidence, but was reluctant to give it significant weight as proof of gang membership. The judge found Garcia's testimony credible and consistent, and noted that the only evidence of gang affiliation was the police report and the informant's unverified claims, including the questionable assertion about a New York gang connection. Ultimately, the judge ruled that Garcia had a well-founded fear of persecution from Barrio 18 in El Salvador and granted him withholding of removal, a form of relief that forbids deportation to a country where the person faces likely harm. The judge did not find the government's evidence sufficient to support the gang membership allegation or to deny Garcia protection.
After the immigration judge found the government's evidence to be insufficient, did Garcia then apply for asylum?
Yes, he did. But his asylum application was denied because he missed the 1-year filing deadline after arriving in 2011. Instead, he received withholding of removal, which is more limited and does not provide a path to a green card, permanent residency, or citizenship.
What happens if Garcia is released from custody in El Salvador and comes back to the United States?
He can be deported again, but not to El Salvador as long as his withholding of removal order is still valid. The United States could only deport him to another country that agrees to accept him.
Would his withholding of removal order still protect him?
Yes. Withholding of removal remains in effect unless a judge formally revokes it or Garcia becomes ineligible for protection. It does not automatically expire if he leaves or re-enters the United States.
Since Garcia is married to a United States citizen and has a child here, Can he become a United States citizen?
No. Withholding of removal does not allow him to apply for a green card or citizenship, even if he's married to a United States citizen. He would need to change his immigration status, which is very difficult and rare.
What about the recently revealed allegations of domestic violence?
On Wednesday, April 15th, the DHS published on social media a court filing from 2021 in which Abrego Garcia's wife, Jennifer Vasquez, had filed for a protective order against her husband. The document stated there were reasonable grounds to believe Abrego Garcia had punched, scratched, and bruised his wife, and that he had ripped off her shirt. No charges appear to have been pressed in the incident. Vasquez claimed she had been in a previous abusive relationship and filed the protective order out of an abundance of caution. She has also been very vocal about demanding her husband's release and criticizing the government for its treatment of him. The allegation is not proven, nor does it in itself change the underlying facts of the deportation case. But when it comes to public opinion, it clearly makes Abrego Garcia a less sympathetic figure, which seems to be the apparent motive of the disclosure. To this day, Abrego Garcia hasn't been charged with a crime in the United States or El Salvador. The Supreme Court of the United States in the 1993 case Reno versus Flores made clear that all persons within the United States jurisdiction have due process rights, even undocumented migrants. To quote Justice Antonin Scalia, "It is well established that the Fifth Amendment entitles aliens to due process of law and deportation proceedings." Abrego Garcia was deported to El Salvador despite a legally binding withholding of removal judicial order and no criminal charges and no due process. A lower court ruling by Judge Dinis wrote that there were no legal grounds whatsoever for Abrego Garcia's arrest, detention, or removal. Rather, his detention appears wholly lawless. The Supreme Court agreed with the lower court and ultimately ruled, issuing a 9-0 ruling requiring the government to facilitate Garcia's release from custody in El Salvador and ensure his case was treated as if he had not been improperly deported. However, the court's language was notably restrained and ambiguous. It did not explicitly require the government to effectuate Garcia's return to the United States, but rather to facilitate it. Since the Supreme Court's ruling, the Trump administration has taken a defiant stance, refusing to actively pursue Kilmar Abrego Garcia's return to the United States. Despite the Supreme Court's clear order to facilitate Garcia's release from custody in El Salvador, administration officials argue that they are not legally required to retrieve him or ensure his repatriation. Instead, they maintain that the court's language does not obligate them to take concrete steps beyond minimal diplomatic communication. Administration lawyers have told federal courts that Garcia remains detained in El Salvador and have declined to disclose any meaningful information about efforts to secure his return. The White House has doubled down on its opposition, with officials reiterating unproven allegations of gang affiliation and declaring that Garcia will never reside in America, promising that if he returns, he will be deported immediately. In public statements, the administration continues to justify its actions by citing public safety and foreign policy, and has even accused Garcia's supporters of supporting terrorism. Federal Judge Paula Zinnes has responded by ordering expedited discovery, requiring the administration to provide documentation and sworn testimony about any steps taken to comply with the court's directive. She has also indicated she may consider contempt proceedings due to the administration's lack of substantive action or justification. In summary, the Trump administration's position is that it is not compelled by the Supreme Court to bring Garcia back, and it is resisting judicial efforts to enforce his return, while continuing to publicly assert that he is a danger and should not be allowed to re-enter the United States.
What happens next?
Based on the most recent developments and the current posture of the case, it is highly likely that the Kilmar Abrego Garcia case is heading back to the Supreme Court after expedited discovery is completed. Here's why. The Department of Justice has already filed a notice of appeal to the Fourth Circuit Court of Appeals, challenging Judge Paula Zinnes' order requiring the government to take all available steps to facilitate Garcia's return to the United States after his wrongful deportation. The Trump administration has made clear it disagrees with the lower court's interpretation of the Supreme Court's directive to facilitate Garcia's return, and has requested that the appellate court suspend Judge Zinnes' order while the appeal is pending. Judge Zinnes has ordered expedited discovery and sworn testimony from government officials to determine whether they have complied with her orders, and has signaled possible contempt proceedings if the administration is found to have willfully defied the court. The administration's filings and public statements indicate it will continue to resist any order to actively repatriate Garcia, maintaining that the courts lack authority to compel the executive branch to take specific diplomatic actions. Given the high-profile nature of the case, the conflicting interpretations of the Supreme Court's language, and the administration's intent to appeal, it is very likely that, after the Fourth Circuit rules, whichever side loses will seek Supreme Court review again.
Thanks for watching. I hope this presents a fuller picture of the Abrego Garcia case.